of their claims, since asylum seekers whose claims have not been properly considered could well be genuine refugees. And as I've explained, refugees must not be returned to their countries of origin. This legal principle of non-refoulement is laid down in the United Nations Refugee Convention, to which the UK is a party. There are also provisions which have the same effect in other treaties to which the UK is a party. The UN Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment, the UN International Covenant on Civil and Political Rights, and the European Convention on Human Rights. It is therefore not only the European Convention on Human Rights which is relevant to this case, as is sometimes thought. There are other international treaties which also prohibit the return of asylum seekers to their countries of origin without a proper examination of their claims. These international treaties are reflected in our domestic law. In the first place, there are several Acts of Parliament which give effect to the principle of non-refoulement as set out in the UN Refugee Convention. They include the Asylum and Immigration Appeals Act of 1993, the Nationality, Immigration and Asylum Act of 2002, and the Asylum and Immigration Treatment of Claimants, etc. Act of 2004. There is also an Act of Parliament, the Human Rights Act of 1998, which gives effect to the European Convention on Human Rights. Again, contrary to what is sometimes thought, the Human Rights Act is not the only relevant legislation. The effect of the legislation, in general terms, is to prohibit the removal of asylum seekers whose claims have not been decided to a country where there are substantial grounds for believing that they would be at real risk of refoulement. The issue the court has to decide is whether the Home Secretary's policy breaches that prohibition. For the asylum claims with which this appeal is concerned, the basis of the Rwanda policy is contained in the Home Secretary's immigration rules, which are statements of administrative practice. Under those rules, asylum claims can be treated as inadmissible if the claimants had the opportunity to apply for asylum in a safe third country but did not do so. The claimants can then be removed to any safe third country which agrees to accept them. A country only qualifies as a safe third country under the rules if the principle of non-refoulement is respected there, in accordance with the UN Refugee Convention. It is the next step which is controversial in these proceedings. That is the Home Secretary's guidance to the officials who apply the rules that Rwanda is a safe third country. That is to say, a country where asylum seekers will not be at risk of refoulement, her certificate, and also her certificates to that effect under the relevant legislation. There is no dispute between the Home Secretary and the claimants in this case as to the legal test which the court has to apply. The test is whether there are substantial grounds for believing that asylum seekers who are sent to Rwanda will be at real risk of ill treatment as a consequence of refoulement. If there are no such grounds, the policy is lawful. If there are such grounds, the policy is unlawful. It is argued on behalf of the Home Secretary that there are no substantial grounds for believing that asylum seekers who are sent to Rwanda will be at risk of refoulement. A memorandum of understanding has been entered into between the UK and Rwandan governments, which includes an undertaking that asylum seekers will not be subject to refoulement. Although the Memorandum of Understanding is not legally binding and cannot be relied on by asylum seekers, The Home Secretary says that Rwanda can be relied on to comply with it. There are financial incentives for Rwanda to comply with the memorandum, and it establishes arrangements for monitoring Rwanda's compliance. As against that, UNHCR, the United Nations Refugee Agency, has produced evidence of a number of deficiencies in the Rwandan asylum system. The relevance of that evidence is that if claims are not dealt with properly, then genuine claims are liable to be wrongly refused. And when claims are refused, Rwanda is entitled, under the memorandum, to expel the claimants to any country where they have a right to reside. The only country where most people have a right to reside is their country of origin. So if Rwanda does not have an adequate system for processing asylum claims, genuine refugees may be returned to their countries of origin. In other words, they may be subject to refoulement. In addition, UNHCR has produced evidence of a substantial number of cases of refoulement of asylum seekers by the Rwandan authorities, including during the period since a Memorandum of Understanding with the UK was concluded. It has also produced evidence of Rwanda's failure to comply with a similar agreement which it entered into with Israel. When this case came before the Divisional Court, it failed to give proper consideration to UNHCR's evidence. That was a mistake. UNHCR has unrivaled practical experience of the working of the asylum system in Rwanda through long years of involvement there, and its evidence requires careful consideration. So the Court of Appeal was right to overturn the High Court's decision and to consider the evidence again for itself. It concluded by a majority that asylum seekers who are sent to Rwanda are at real risk of refoulement, and that the policy is therefore unlawful. The question for this court is whether they were entitled to reach that conclusion on the evidence. The Court of Appeal based their conclusion on the following evidence. First, Rwanda has a poor human rights record. In recent times, British police have had to warn Rwandan nationals living in the UK of credible plans by the Rwandan government to kill them. In 2021, the UK government criticised the Rwandan government for extrajudicial killings, deaths in custody, enforced disappearances, and torture. There are also concerns about media and political freedom in Rwanda. Since Rwanda has ratified many international human rights conventions, this evidence raises questions as to its compliance with its international obligations. It's also relevant to the question whether the Rwandan courts can be expected to act independently of the Rwandan government when deciding appeals against the Rwandan government's decisions on asylum claims. Secondly, UNHCR's evidence is that there are systemic defects in Rwanda's procedures and institutions for processing asylum claims. To mention only some of the points raised, they include, first, concerns about the asylum process itself, such as the lack of legal representation, the risk that judges and lawyers will not act independently of the government in politically sensitive cases, and the fact that the right of appeal to the High Court, which has existed in theory since 2018, has never, in fact, been exercised. Secondly, Rwanda's 100% rate of rejection of asylum claims from countries in known conflict zones from which asylum seekers removed from the UK may well come, such as Syria, Yemen, and Afghanistan, although the UK authorities often find that such claims are well-founded. Thirdly, Rwanda's practice of refoulement, of which UNHCR gave over 100 examples, which continued during the period after the UK's agreement with Rwanda was concluded. And fourthly, the Rwandan government's apparent misunderstanding of its obligations under the Refugee Convention. The third matter raised in UNHCR's evidence is Rwanda's failure to fulfill undertakings which it gave to the government of Israel under an agreement for the removal of asylum seekers from Israel to Rwanda, which operated between 2013 and 2018. In terms of the agreement, asylum seekers sent from Israel to Rwanda were to be allowed to claim asylum there, and there was an explicit undertaking by Rwanda to comply with the principle of non-refoulement. The agreement was therefore similar in those respects to Rwanda's agreement with the UK. Despite the terms of the agreement, asylum seekers who were sent to Rwanda by the Israeli government were routinely moved clandestinely to a neighbouring country from which they were liable to be refouled. That evidence is not contradicted, and it raises a serious question as to whether the undertakings given by Rwanda under its agreement with the UK government can be relied on. As I've explained, the legal test which has to be applied in this case is whether there are substantial grounds for believing that asylum seekers sent to Rwanda would be at real risk of refoulement. In the light of the evidence which I have summarised, the Court of Appeal concluded that there were such grounds. We are unanimously of the view that they were entitled to reach that conclusion. Indeed, having been taken through the evidence ourselves, we agree with their conclusion. We accept the Home Secretary's submission that the Rwandan government entered into the agreement in good faith, and that the capacity of the Rwandan system to produce accurate and fair decisions can and will be built up. Nevertheless, asking ourselves whether there were substantial grounds for believing that a real risk of refoulement existed at the relevant time, we have concluded that there were. The changes needed to eliminate the risk of refoulement may be delivered in the future, but they have not been shown to be in place now. The Home Secretary's appeal is therefore dismissed. There is also a cross-appeal on behalf of one of the asylum claimants who argues that the Rwandan policy is in breach of retained EU law, as well as being unlawful for the reasons that I've already explained. We reject that argument on the basis that under an Act of Parliament enacted in 2020, the EU provisions in question ceased to have effect at the end of that year. The cross-appeal is therefore also dismissed. The Court will now adjourn.